Welcome to Epstein Becker Green's webinar, Corporate Behavioral Healthcare Not So Fast, part of our Behavioral Healthcare Crash Course webinar series. We are pleased to have Epstein Becker Green's Kevin Ryan, who is a member of the Healthcare and Life Science practice in our Chicago office. Before we begin today's presentation, please be informed that today's webinar is being recorded and the participant phone lines will be placed on mute throughout the program. Due to the time limitations, you are welcome to submit questions directly to the presenter following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. At this time, I'd like to turn the webinar over to Kevin.
Thank you, Lisa. Okay, this information, the presentation that has been provided is for informational purposes only. It's not intended and should not be construed as to constitute legal advice. Please consult your attorneys in connection with any fact-specific situation under federal, state, or local laws that may impose additional obligations to you or your company. And the Cisco WebEx is being used to record this. This is attorney advertising, and there's my contact information, as Lisa mentioned. Okay, thank you again for joining. This is a 15-minute seminar on behavioral health care, not so fast. Hopefully today, in very short order, we will go over some of the concepts of corporate practice of medicine and other professional services, including touching briefly on who is allowed to employ licensed professionals, professional corporations, the management of professional corporations, national expansion for behavioral health programs, and scope of practice issues. And you may ask, well, why is this important if I'm looking to provide behavioral health care? And we are seeing several of our behavioral health care clients expand from being very small, locally owned practices or organizations to regional and even national practices or organizations. We know that the American Psychological Association is encouraging alternative practice models to its members, and we are seeing many developers who are getting into the mobile and the telehealth technology and space, and private equity who are also investing in behavioral health care organizations. And so as they try to expand and play on a national basis, it's important to understand these concepts. And it's much easier and better to understand them at the beginning of a project as opposed to expanding and then finding out that that expansion was not in compliance with state or federal law. So what is the corporate practice of medicine? In many ways, the corporate practice of medicine is a catch-all phrase which addresses the fact that in many states, a general business corporation cannot own or practice a profession. And this concept goes way back to the early 1900s when the Montgomery Wards of the world and Sears were actually putting in dental practice and optometry practices in their stores. And so states passed laws which are very similar to the statute that we see here from California, which defines medicine as any person who practices or attempts to practice or who advertises or holds himself or herself out as practicing any system, remote or treating the sick or afflicted in this state, or who diagnoses, treats, operates for, prescribes for any ailment, blemish, deformity, disease, disfigurement, disorder, injury, or other physical or mental condition of any person. And there are similar provisions in other states to this, but this doesn't just apply to medicine, even though the phrases people frequently refer to as the corporate practice of medicine, prohibition. There also are similar prohibitions for many of the other licensed professionals, including dentistry, optometry, veterinary practices. But on the behavioral health side, obviously on medicine, it addresses psychiatrists, but there also are provisions which include psychologists, social workers, therapists, and in some states, such as New York, any licensed professional is covered under these prohibitions. So what are the practical aspects on this corporate prohibition on, or the prohibition on the corporate practice of medicine? It limits who can actually own a professional practice. In many cases, the professional practice is limited to the profession, to a professional. And almost everything that I will say in the next 15 minutes is, it will vary depending upon the state. So in some states, various different professionals can own a practice together, and in some states that is not true. Only licensed physicians can own a practice, or all licensed psychologists can form a practice together, but a psychologist and a psychiatrist cannot practice together. It varies on the state, it varies on the professions. And so again, this is why it's important to understand this as you're trying to expand a practice or a program on a national basis. It also, many of the prohibitions restrict lay people from owning an interest in a professional practice, but again, that's not always true. In some states, as long as a majority of the practice is owned by a professional, then that's okay. The same with a general business corporation. In many states, a general business corporation is strictly prohibited, and in some states, they can own up to a 49% interest. And in a few states that don't have the prohibition on the corporate practice of medicine, then a general business corporation could actually own a professional practice. Again, it's state-by-state analysis. And in many states, there are exceptions for ownership by hospitals, by HMOs, and certain other licensed entities. So you do hear about, expansion or a program that's being rolled out that seems to be offering services, and perhaps what you're hearing about are actual management companies who are managing behavioral health care practices pursuant to management agreements. And in these cases, it's very important that when there is a management agreement, that the professional decision-making has to be left to the professionals. The advertising of the professional services can usually only be done by the professional themselves. How many patients to see in a given period of time is frequently one of those things that can't be determined by unlicensed people. And finally, the determination of tests that are appropriate for a particular condition can only be done by a professional. In some states, the fees themselves have to be negotiated or approved by the professional, even if there is some assistance from the management company. You'll also hear about prohibitions on fee splitting, and that's where corporate or professional fees come into a practice that a professional cannot share them with a general business corporation or a management company sometimes. And in some states, like New York, Illinois, a few other states, management fees cannot be on a percentage of revenue or a percentage of collection basis, except for in very limited circumstances, maybe billing and collection, but the management services themselves can't be a percentage, or it's considered a violation of the fee splitting legislation. So what happens if you violate the prohibition on the corporate practice of medicine? In some states, it's actually a felony. It can be a fine. There can be prison. Most likely, there can be licensure action by the state agency taken against the professional who is considered to have violated the prohibition. And they can also pursue anyone who aids and abets the violation. So obviously, if a general business corporation or a layperson who isn't licensed, the state agency can't take action against that person's license. So instead, they may prevent them from operating in the state. If they're already existing, they could close the business down and prohibit them from continuing to practice or operate the business in the state. Also, there can be lawsuits by payors or professionals for breach of contract. Frequently, you hear about violations of the prohibition of corporate practice of medicine from payors who have decided that they were paying an entity that wasn't entitled to reimbursement, and they seek repayment of amounts paid. Last summer, the Attorney General of New York settled with Aspen Dental Management, Inc. on alleged violations on the prohibition of corporate practice in New York. Aspen Dental Management was fined $450,000 and was required by the Attorney General to change its website, its billing practices, its banking practices, and its internet practices, and also the interactions with the staff at the various practices. So if you're going to do this, what do you do? Frequently there is a professional corporation that is set up, which is owned by the management company, and then or is owned by the professional, sorry about that, and associated, it may be someone associated with the management company who has friendly ties to that, which is why it's called a friendly tie. Many of these management agreements will enter, management companies will enter into a stock transfer agreement between the management company and the professional. Now, that doesn't mean that the management company owns stock, but they may be able, through an agreement, to direct who the owner of that professional corporation ultimately is, so long as they're qualified to hold that ownership. There are some states that actually restrict the use of these types of agreements. New York comes to mind as one that does not favor these types of services. And then there may be a professional services agreement and management services agreements between the parties to address the relationships. So if you're trying to expand on a national basis, what can you do? In some cases, clients actually set up a professional corporation in each state in which the management company will operate, or in which they want a professional corporation to operate. Or another option is that you can set up a professional corporation in a state and then try to qualify it as a foreign corporation in other states. Not every state allows foreign professional corporations. A state like Michigan requires that a domestic professional corporation be formed, and so you can't have just one that qualifies in all 50 states. You will end up with a multitude of professional corporations. And so, scope of practice in just the last couple minutes here. It's important to know, as you do start to expand, that state licensure laws may govern the scope, or obviously govern the scope of practice by professionals, and it varies widely by states. For example, a nurse practitioner can do things in certain states that they can't do in others, including dispensing. There may be supervision type of requirements that are very specific to a state, and there are certain things that may be unlicensed individuals, such as wellness and coaching in some states, where in other states there may be some licensure of that. So you have to be very, very careful. As you start to expand, again, it's very, very important to look at these things on a state-by-state basis. And that is, this is the scope of practice issues on this, and hopefully, although it said not so fast at the very beginning, this was very fast. This is part of the webinar series that we're doing on behavioral health crash course, and there will be 2 upcoming webinars, 15-minute webinars, over the next couple weeks. On March 22nd, Leslie Young will be talking about the mental health parity implementation. Are we there yet? And then on March 29th, Jackie Selby, managed care and behavioral health care. And I believe that that takes me just to about the end. So as Lisa said, if you do have questions, feel free to email me, and we'll try to get back to you. And in a few days, we'll let you know when this will be available as a recording. So thank you for participating, and we hope you'll be able to participate again. Thanks.
Thank you, everyone.